on each page of this 6-page plea form?
Yes, ma'am.
Did you understand everything contained inside the plea form?
Yes, ma'am.
Do you understand that you're giving up your right to a jury trial?
Yes, ma'am.
Miss English, do you understand that you are giving up your right to require that the state of Florida prove beyond a reasonable doubt each and every element of each and every one of the charges that they have charged against you?
Yes, ma'am.
Do you understand you're giving up your right to remain silent?
Yes, ma'am.
Do you understand you're giving up your right to see and hear witnesses testify for and against you at trial?
Yes, ma'am.
Do you understand you're giving up your right to subpoena witnesses to testify on your own behalf?
Yes, ma'am.
Do you understand you're giving up your right to have Ms. Fox cross-examine state witnesses on your behalf?
Yes, ma'am.
Do you understand at trial that you would have the right to testify or not to testify? Do you
Yes, ma'am.
understand that? Understanding all those rights, do you still wish to enter your plea of no contest?
Yes, ma'am.
Do you understand that if the court accepts your plea, you give up each of these rights, that there will be no trial or appeal, and all that will be left for the court to do is to impose a sentence? Do you understand that?
Yes, ma'am.
Has anyone forced you, coerced you, or threatened you to enter this plea?
No, ma'am.
Are you entering this plea because you believe it is in your own best interest to do so?
Yes, ma'am.
Are you entering this plea freely, voluntarily, knowingly, and intelligently?
Yes, ma'am.
Do you have any history of mental illness?
No, ma'am.
Are you under the influence of anything today that might affect your ability to understand what's happening here?
No, ma'am.
Do you understand that if you are not a United States citizen, that your entry of this plea may subject you to deportation?
Yes, ma'am.
Miss English, have you had an opportunity to thoroughly discuss your case with your attorney, Mrs. Fox, who is present with you today?
Yes, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Have you had an opportunity to discuss with Mrs. Fox any potential factual or legal defenses that might result in the suppression of evidence? In fact, we addressed one of those motions already in this case, which was a motion to suppress your statements. Did you have an opportunity to thoroughly discuss those types of things with your attorney, Ms. Fox?
Yes, ma'am.
Do you have any additional questions of Ms. Fox with regard to anything about your case? I'd give you time in private if you needed additional time to speak with her. Do you need additional time?
No, ma'am.
Have you understood everything that I've said today?
Yes, ma'am.
And I just want to confirm you are satisfied with Mrs. Fox's services.
Yes, ma'am.
Ms. English, have you had the opportunity to discuss the provisions of the Jimmy Rice Civil Commitment Act with Mrs. Fox?
Yes, ma'am.
So you understand that if this were a sexually violent or a sexually motivated offense, or you had previously been convicted of such an offense, your plea today may subject you to an involuntary civil commitment proceeding and a designation as a sexually violent predator. According to your history, it does not appear to apply to you. I ask that question in each case. Do you understand that?
Yes, ma'am.
There are some unique aspects of your case that legally I'm required to review with you. Do you understand that the crime of theft is enhanceable? Let me rephrase it another way.
Yeah.
Do you understand that because you are entering a plea to a charge of theft, and you will be convicted of a charge of theft, that if you were to be arrested in the future, even for a petty theft, that your plea today may subject you to an arrest in the future for a more serious offense, meaning it would bump it up to a higher level misdemeanor or felony if that would be the case. Do you understand that?
Yes, ma'am.
Mrs. English, do you also understand that you have agreed in your plea negotiation to an amount of restitution? That amount of restitution is $120,343.35. Do you agree to that amount?
Yes, ma'am.
Do you understand that you are entitled to have a hearing that would require the state of Florida to approve and establish that that is the amount of restitution due and owing to the alleged victim in this case?
Yes, ma'am.
Are you waiving your right to have a hearing on restitution?
Yes, ma'am.
Mrs. English, do you also understand that as a part of your plea negotiation that you have agreed to pay a a specific certain amount, as in for a condition of your probation. As represented by your attorney, that amount is $500 per month. Is that your agreement?
Yes, ma'am.
Do you believe that you will have the financial wherewithal and ability to satisfy that amount on a monthly basis?
Yes, ma'am.
Right? Ms. Fox, have you reviewed the discovery disclosed by the state?
I have, Your Honor.
Did the discovery include a listing or description of any physical items of evidence, if there were any?
Yes, it did, Your Honor.
Have you reviewed the nature of the evidence disclosed through discovery with Ms. English?
Yes, I have, Your Honor.
Are you or Ms. English aware of any physical items of evidence disclosed by the state for which DNA testing might exonerate Ms. English?
You're not aware of any items like that, Your Honor.
Mr. Plattner, is the state aware of any items of any physical items of evidence for which DNA testing might exonerate Ms. English?
No, Your Honor, the state does not believe there are any DNA issues applicable to this case.
And Mr. Plattner, you indicated that there are no costs of investigation that are being sought by the state in this regard. Is that correct?
That's correct.
Ms. English, have you reviewed the score sheet that has been prepared by the state?
Yes, ma'am.
Is it true and correct?
Yes, ma'am.
Mrs. Fox, did you review this with Ms. English, and is this true and correct?
Yes, Your Honor. I didn't see what Mr. Plattner passed you. I assume it's the same copy as what we had before.
That's right. Shows the 51.6
Yes.
points.
Yes, Your Honor.
Ms. English, the court has reviewed the file, and I do find a sufficient factual basis for your pleas of no contest to the offense of first-degree grand theft, a first-degree felony punishable by up to 30 years, and official misconduct, a third-degree felony punishable by up to 5 years in the Florida State prison system. I accept your pleas of no contest. I do find that they are freely, voluntarily, knowingly, and intelligently made. I am adjudicating you guilty on each count before the court imposes sentence. And is there any legal cause to show which would preclude the imposition of a sentence at this time?
There's no legal cause, Your Honor. As we stated, we did want to ask for the vote.
Okay. Pursuant to Rule 3.270 subsection B, the court shall now entertain submissions and evidence by the parties that is relevant to the sentence, including any victim impact statements pursuant to statute 921.1432. Mr. Plattner, does the victim wish to give a victim impact statement, sir?
I don't believe there's anything that we desire to present this time.
All right, thank you very much. Mrs. Fox, I will now hear your motion on behalf of Ms. English regarding her request for a deferment of the sentence. You may proceed.
Thank you, Your Honor. This is our motion to defer sentence. Ms. English had a planned trip with her. Her father was 82 years old, was supposed to come. She lives in North Florida now, Ms. English. He was supposed to come to North Florida. She has two siblings that were going to come also. They were going to have a Thanksgiving family reunion. Of course, that was very important for them to get together because of this happening today. Her father suffers from congestive heart failure. At the time he was supposed to get on board the flight, the doctor did not think it was safe for him to do so. The other family members did not want him exposed to, and Ms. English didn't either, to anyone who might even have a slight cold or anything like that, so they canceled the entire trip. Her sister has indicated that she will, if possible, and if Ms. English is there, bring her father down on December 20th for the Christmas holiday. This was unexpected. I, in fact, asked her, well, why didn't you just go to Texas? The first reason was that nobody was supposed to be around him. The second reason was she was concerned to leave the state of Florida when she had the sentencing pending, which I thought was actually wise of her. We are asking Your Honor to allow her. I understand there might be limited time period when you're here, but we are asking for her to come back at any time after Christmas. It could even be the week after, if you had any time availability, or the beginning of January for her sentencing, so she can see her father, because he is elderly and suffering from health problems. We would also hope if he passes, Your Honor, while she's in custody, that I would be asking for a DOC furlough for her, which I understand would have to come through you, which we would be hoping to get at that time, which hopefully won't be too soon, but we would like her to be able to see him on this time.
Thank you, Ms. Fox. Does the state wish to be heard in response to the request regarding sentencing?
Your Honor, we have no position one way or the other on that.
Thank you. The request is denied. Earlier this year, and at rest of the parties, this court explained that based upon the facts as I was aware of them, I would not accept a previous plea negotiation. And I had given the case law that I relied upon to do that. This court did reject a disposition that was originally agreed to by the defendant in the state. I am finding a sufficient factual basis for your entry of a plea of no contest, and in so finding, Ms. English, the court is left with two unmistakable facts. Number one, you violated a position of trust as it relates to the finances of the Sheriff's Department. And number two, you violated a position of authority as a sworn law enforcement officer. Your actions are the embodiment of corruption. You committed the offenses quite simply because you could. As to count one, the court adjudicates you guilty, sentences you to serve 48 months in the Florida State prison system with credit for all time served. Said sentence to be followed by 20 years of supervised probation. This is a split sentence. Special conditions of your probation are that you shall pay the agreed upon restitution amount of $120,343.35, payable at a rate of $500 per month, as in for a condition of your probation. If you satisfactorily complete the payment of that restitution to the Hendry County Sheriff's Office, you may petition the court to terminate your probation early. You will be required to pay court costs of $395, cost of prosecution of $100. I'm not going into the details about if you pay in the first 2 years, because it appeared to me that Mr. Plattner clarified that or expanded it to indicate that upon satisfactorily paying off the restitution amounts, she could move to terminate her probation early, which every defendant is entitled to do. As to count two, official misconduct, you are adjudicated guilty of the offense. I am sentencing you to serve 48 months in the Florida State prison system with credit for all time served. Said sentence to run concurrent with count one. There is no probationary sentence relating to count two. You will be fingerprinted in my presence. You will be required to submit to a DNA sample. You'll have 30 days to place an appeal. Are there any other matters that we need to address as it relates to Ms. English's sentencing?
Not from the state.
No, Your Honor.
Thank you. You'll be fingerprinted in my presence. I have signed the judgment and sentence. It was prepared.
Thank you, Your Honor.
Thanks.
Yes, court will stand in recess.
Have a good day.
Thank you. You too.
Bye, Your Honor.